Okay, the end is nigh. This is the last chapter of material that we're going to cover. Once again, there is no chapter in my textbook on this, and I think that my overheads in my lecture should be more than adequate to cover the topic. So, international business transactions. Obviously, the first step we have to take is to really look and see what international law is. And it's defined on slide 130 as a body of rules and norms that regulate activities carried on across legal boundaries of nations. In my international business law class, IBUS 340, I provide an article which I think I'll post just so that you can have a quick look at it. The reason for the article is kind of irrelevant. But what the author of the article did in passing was really commented on, what is international law? Is there such a thing as international law? And what he said was that, in fact, there was no international law because there was no conformity of prohibitions and punishments. In the Canadian legal system and in British Columbia, we have criminal law, we have contract law, we have tort law, and all those have prohibitions and punishments associated with them and a means of enforcing them. Okay, but internationally, a lot of times there are rules which you think you'd have to follow, but there is no way of enforcing them. So he did say, though, that there are law-like regimes. And so what we have to look at is comment briefly on public law and private law internationally. Public law is attempts to regulate things between states or between states and persons or organizations. And then there's private law, which tries to regulate legal matters between persons of one state and persons of another state. And it's this third category that we are really going to concentrate on. But getting back to his idea of law-like regimes, there are methods of enforcing contractual obligations across borders. They're fraught with all sorts of problems, but they're there. There's conventions like the International Convention on the Sale of Goods, which operates cross-border. There's the Convention on the International Transportation of Goods by Sea, which have regulations which can be enforced cross-border. But then there's also things like criminal matters, very much a state matter, and so there's no cross-border activity with respect to those, but we don't really worry about those anyway because we're looking at international business transactions. All right, so the first thing we're going to do is go back to talking about the three main legal systems of the world because they clash and there are differences, and that affects private law as well as public law. So there's civil law, which is on slide 131, and it's a comprehensive set of rules, laws organized in a code instead of spelled out on precedent as we do in common law. If there's no specific section in the code, then what you have is a situation where the courts attempt to extrapolate by finding the closest section and then applying it. And then eventually, if that particular problem crops up time and time again, then the legislatures will actually change the code, put in a new article. Originally it started in Roman times with the Justinian Code. We get our word justice from Justinian, he wasn't named after justice. And the reason for him, or for us saying justice as following his name, is because of what he did. When Rome was past its height and the barbarians were gathering strength and marching on Rome, the advisors to Justinian came to him and said that the Roman army was no longer strong enough to stop the barbarians and that they were going to plunder Rome and that they were going to steal gold, silver, tapestries, statues, cause all sorts of havoc. And so they said to Justinian, you should take all those things of wealth and hide them. But he had a different attitude of what was wealth, what was of value, that should last from the Roman Empire. And so he thought it was the laws, because they had a very comprehensive legal system in which senators acted as lawyers in courts. And there was a saying that a Roman could go anywhere in the Roman Empire and be safe. Not totally true, but the concept was that the laws applied to Romans throughout the empire. So what he did was he painstakingly wrote out all the articles of their law in a comprehensive document called the Corpus Juris Civilis Romani. And I've got a little image on the screen there if you want to have a look at it. And so what that means is the body of law, civil, for Rome. And he took those scrolls and he hid them away in monasteries, and Rome was plundered. And gold and silver was stolen, tapestries were burned, statues were smashed, but the scrolls survived. And in the monastery, they began to study them, and they copied them, and they sent them to other monasteries, and then they also went to universities. Back in those days, universities weren't like, well, let's go and get a degree so that I can go out and be a Roman businessman. No, universities were designed to expand human knowledge. Okay, and you went to university and you spent your whole life there, sort of like what you feel like you're doing right now with all the courses. But anyway, the universities studied them, and then estates began to form throughout Europe. They obviously said, hey, here's a set of documents that we can use to develop our laws. So it became pretty common all over continental Europe, northern Africa, and a lot of the Middle Eastern countries. And then along comes a guy by the name of Napoleon, and he decides to conquer the world. He doesn't do quite as good a job as the Romans, but he had a large number of states in continental Europe that he conquered. And he thought of himself as a bit of a legal jurist, and his best friend was a legal jurist. And so the two of them took the Justinian Code, and they developed what's called the Napoleonic Code, or Code de Napoléon. And we can see that on the next slide, a little picture of the book. The Code Napoleon was a thinly disguised copyright infringement of the Corpus Juris Civilis Romani, and he imposed that particular code on all the countries that he conquered. Well, eventually we got rid of those countries got rid of Napoleon, and after he was gone, they thought, hey, that's we're glad we're rid of him, but gosh, his code worked really well. But they couldn't call in Germany the German code the Napoleonic Code, so they call it the Germanic Code, and they all developed the good concepts from that. And you almost think that, well, then the codes must be similar. Or almost identical, but they're similar in that they're one document that you look to make judicial decisions. But even within civil law, there were differences. The Germanic Code, for example, was very precise. It had this, and that's what happened, and this is the result, and you will do this. Whereas the French was qu'est-ce que c'est, semblait, il fait bon, n'est-ce pas? A much more living document following the Revolution. The laissez-faire attitude, but always it's the code that you look at. You do not look at cases. So what happened in the courthouse last week on a similar case is totally irrelevant. Continental Europe had civil law. The Middle East had civil law. The expansion of the colonies of the European countries took civil law to South America, Latin America, Mexico, and parts of Canada and the United States. And it was always, there are characteristics there, like you are in criminal matters generally guilty until proven innocent. It's inquisitorial, which means the judge actively gets involved in the trial and can call witnesses and question witnesses, unlike our system where the judge is considered to be an impartial, unbiased observer of fact, sits back and watches what goes on. Okay, so that's the civil law system. The next one we want to talk about is Muslim law. It's called the Sharia, and it's derived from four things. Number one, the Quran. Number two, the sayings and decisions of the Prophet Muhammad. Number three, the writings of Islamic scholars. And number four, the consensus of the legal community. The Quran is their guiding document, and there's a great deal of similarity between the Quran and the Bible. I didn't know this when I first started teaching my international trade law class, but I had a mixture of students and from other countries, which is, the best way to get an education. And one of those students was from Lebanon, and she had a copy of the Quran, which was considered to be the closest and precise translation from the original language. And she said she would lend it to me, and she did. And then at the end of the course, she very kindly gave it to me. So I was reading the Quran, and I also had another student who knew of an Islamic scholar who lived in Victoria, BC, and said that he would come over and be a guest speaker. And I said, well, we don't have any funds for that, so it's pretty hard to do that. And the young fellow said, no, he'll go anywhere, anytime, and talk about the Quran and the Sharia, because he was so terribly upset that what we learn about it comes from Americans like George W. Bush or worse still, President Trump. So we arranged to have him come over, and I was reading the book very quickly in the hopes of getting it through before he arrived. And I only had a couple of pages left when he burst into my office, and he said who he was, and we shook hands. And his first question was I a Muslim? And somewhat surprisingly to both him and me, my answer was yes. Okay. Because the Quran is very similar to our Bible, and Allah is the same God as in the Bible. I'm sorry if that upsets some of you, but it's just a fact of life. There's Moses in the Quran, there's Moses in the Bible. Moses went up the mount, he brought down the Ten Commandments in the Quran, and he brought down the Ten Commandments in the Bible. And I believe I can remember that Moses in the Quran talked to the burning bush, which was God in disguise, and Moses talked to the burning bush in the Bible. So there are some very strong similarities, at least with respect to the First Testament, and then the Second Testament is where things went a little awry. But anyway, I said yes, I was a Muslim, which because not because I believed in the one God, but because I understood that the gods were the same. And when I say not because I believe in the one God, I'm not sure whether there's a God or not, and I'm not going to waste any time worrying about it, because theologians can debate the issue until the cows come home, and they can never convince an unbeliever that there is a God, and the atheists can argue and argue and argue, but they can't say for certain whether there is or isn't a God. So my attitude, just so that you know where I'm coming from and my bias or lack thereof, I think, is that I'm not going to waste any time on it. I could spend my whole life worrying about it and spending time debating about it, but in the end, the only way I'm going to find out is when I pass away. So my attitude is live your life in the best possible way, and always be cognizant of what you do, whether it's going to hurt somebody else. And then you die if there's a God. Well, if that isn't good enough, I'm on my way to hell. And but hopefully it would be. And if there isn't a God, there's just oblivion. Then I haven't wasted any time worrying about it. But having said that, we have to look at these religious aspects as they affect the law. Anyway, he went to my class, and he talked about the Sharia, And very obviously, there is a fair amount of detailed law in the Quran, a lot more procedural law than is in the Bible. The Bible, thou shalt not kill, is substantive law, but the Quran actually has quite a bit of procedural law. We're not going to get into that because we just want to understand that there are the separate legal systems. Okay, so there's the writings of the Islamic scholars. This is where the Osama bin Ladens come into it. They take the Quran and they tell people what's in it, twisting it to serve their own purposes, because a large portion of the population over their history has not had a tremendous amount of schooling, and so they depend on the scholars, and obviously they have their sects, just like we have the white supremacists and the problems in our religion, or Christian religion as well. So the writings of the Islamic scholars deriving rules from analogy from the principles in the Quran and the Sunnah. And then the last one is the consensus of the legal community, and that's where we see some influences of civil law and common law, mostly civil law though, because France had a huge empire throughout the Middle East, and when the Middle Eastern countries got rid of France, they decided to go back to the Quran, the Sunnah, and the writings of the Islamic scholars. But then they said, well, a lot of the procedural matters in the civil law that France tried to impose on us worked really well, and so they kept some of those laws and adopt them into their legal system. Egypt, for example, is quite schizophrenic because the French were in there, and then the British went in and kicked the French out, and then eventually the Egyptian kicked the British out. And so the French influence can be seen there, and the common law influence can be seen there, as they adopted the best practices and then went back to their own religious the law and the legal basis that comes from it. Okay, so more people in the world covered by Islamic law, and then that brings us to the British system, which is the common law system. It's the interpretation of law on the given subject through the influence of previous court decisions. If there's no specific decision, then the common law judge is entitled to make a decision and create new law. So this is called stare decisis, to stand by previous decisions, and the only reason that England has common law is because by the time the Roman army got to the British Isles, it was two problems. Number one, it was not strong as it was, and number two, the army was made up of mostly barbarians. As Rome conquered countries, they would very quickly improve the economic conditions, bring in law and order, and then they looked around at all the soldiers that from the defeated army, and they thought, okay, now there's a lot of unemployed people whose only skill is killing, and so why make them unemployed? And they asked them to join the Roman army. Better uniforms, better pay, travel. Sounds like a U.S. Marine Corps a recruiting poster, doesn't it? But anyway, they would bring them into the army for two reasons. Number one is that would make it less likely they would rise up against the Roman rulers. And number two, you can only fight so many wars before you start running out of Romans. Okay, so anyway, by the time the Roman army got to the British Isles, the only Roman in it was the Roman governor. And so the Roman governor thought, oh, okay, there's no way I can instill Roman law using barbarians to try to rule barbarians. And so he allowed England, the people of the British Isles, to keep their own laws, which were barbaric, to say the least. If it was a public law matter, a crime, they had ordeal by fire or ordeal by fire, or there's another one that'll come to me. Ordeal by fire. If you were accused of a crime, they would heat up a red-hot poker and they would put it in your hands, and you had to walk 30 paces without dropping it. If you dropped it, you were guilty. Okay. If you made it 30 paces and then dropped it and had blisters, you were guilty. Well, you were guilty. And the other one is trial by ordeal. Or dunking. They used to attach you to a big pole, and they would put you into the water and hold you under the water to see if you drowned, or they'd throw you in the water tied up, and if you sank, you were innocent. If you floated, you were guilty. You're guilty. So public law matters were brutal. Private law matters, breach of contract, hand-to-hand combat. Okay, so if you and I had a dispute over a pig, that's my pig, no, that's your pig, no, that's my pig, we would fight it out, hand-to-hand combat on the field the next morning. What happened, of course, was the weaker person, for example, I used to do this in class, and there would be a really big student, and I'd say, okay, you and I have a dispute. Okay, let's fight it out. And he'd stand up, and I'd go, oh, no, I'd rather fight you, some smaller student. Well, if it was a large student and he was stronger and younger than me, what I would do is I would hire one of the knights, a trained warrior, to fight for me, and I'd give him some silver. Well, the big guy would go, whoa, okay, I could have beat Peter, but I can't beat the knight. So he would then hire a knight. And then the ludicrous thing is there's this person and I who have the dispute standing on the field in the morning watching these two knights fight to the death. Okay, so, one knight would, skewer the other guy, and that guy would go, and hack the other person, and one of them would die, and that, okay, I won, you have to compensate me for the pig. Well, one knight would be dead and the other one would be wounded, and they'd take the wounded one to the hospital, right? No, they didn't have hospitals. They'd take him to a monk who would, do some incantations and, put a little bit of, spices or herbs or, leaves or moss on the wound and you cauterize it with an iron. And next thing you know, gangrene or infection would ensue and the knight would die. And then eventually the king would say, hey, let's have a war. I'm going to conquer this castle over here. And he would call all his knights, and 2 or 3 guys would turn up. Where are my knights? Well, when there was no war, the knights were unemployed. How did they make a living? They would ride around England and they would hire themselves out to fight for people. I can remember when I was a young lad, it was a TV show called Ivanhoe. Ivanhoe, and he was riding along on his steed with his shining armor. And I thought, wow, I want to be a knight when I grew up. He was riding around London and he was, fighting for justice. Well, no, he wasn't. They were paying some money to fight another knight to decide whose property had been trespassed on and stuff like that. So obviously that system didn't work very well, and eventually they developed a court system which really stemmed from the Magna Carta. Okay, and I mentioned earlier on that the Magna Carta was really important to me. Once the Magna Carta was signed, Article 18 of the Magna Carta, and initially there were no numbers, by the way. It was just a long series of paragraphs, and it wasn't until years later when a legal jurist in England broke it down and put the paragraphs in. But the paragraph 18 talks about, and this is on slide 135, we, or if we should be out of the realm, or our chief justiciar, which is judge, will send 2 justiciars through every county 4 times a year, who shall, along with 4 knights of the country chosen by the county, our county, hold court Okay, so the idea is judges would go out and make these decisions, and they had to have some punishment. Okay, now if it was a contract matter, the knights had no involvement because it was just damages would be paid from one person to the other on the decision of the judge. But if it was a criminal matter, then the knights were there to take the person into custody. And bingo, our court systems are created, and then eventually the judges, or pardon me, let's back up. I have a dispute with that big burly neighbor of mine, and now we don't do hand-to-hand combat where he would have had an advantage. All we do is we go into court and we speak. Well, he could kill me with a sword, but he can't out-talk me. Okay, so what's he do? He goes out and hires someone to speak on his behalf. Well, I could have out-talked him, but I can't out-talk this other person, and so I go out and I hire someone to speak on my behalf. And who did you hire? Well, it had to be somebody that was really well educated. So right off the bat, you think, oh, priests and the clergy. But no, there was a separation of church and state. So the people that were hired the most often were actually wine merchants. Glass of wine, and hence the concept "call to the bar." That's a joke. Okay. I would hire a wine merchant. Why? Because they were well educated in business. They were very well spoken because they had to negotiate contracts. They traveled. They knew numerous languages, and they understood commerce. So obviously, they were the best people. Well, a wine merchant could take a bag of gold because it's heavy. And they could go to France and hope not to get robbed. And then you could buy wine and then try to get the wine back to England without being robbed. Or you could just talk and people paid you. So a lot of them became full-time advocates and eventually became lawyers. Okay? And so they, in effect, replaced the knights. And that's why I always say that lawyers are your knights in shining armor. And in class, I generally get a lot of laughs when I say that. But it's true because the knights fighting on the plain in the morning, it was adversarial, okay? Not inquisitorial, as with the judge getting involved in civil law matters. It was adversarial. We were standing there, unbiased observers, okay? And the two did battle. Well, lawyers replaced the knights, and so the common law system is adversarial in nature. The judge is an impartial, unbiased observer of fact. He or she just sits there, and the lawyers do battle. Okay, so a judge would make a decision, and eventually those advocates would ask the judge to write it out, because then they could go in the next time there was a similar problem, and they could say, your brother judge in this courtroom, made this decision. And eventually it became so much a part of the system that judges began to feel bound to follow the decision of their brother judges. And I'm saying brother because there were no female judges in those days. And then, bingo, the whole concept of stare decisis was created, the basis of the common law system. And it was only because Rome was too weak to instill civil law, and then eventually they were repelled from the British Isles, and the English system developed. All right, so the actions in the court. What can the judge do? There are no hard and fast rules. They do not go to judges' school and learn how to do these things precisely. But generally, the rule has been that if there are two cases in BC, I think I've got a separate article that I'm going to attach to eLearn that explains it in more detail. But this is in the textbook as well, okay? If I was suing Graham, so it's Holden versus Graham, and we're in court, and I bring in some cases that help my my position and Graham's lawyer brings in cases that help his position, then the judge has to decide what to do with all those cases. And if the judge doesn't do or consider the cases, then this is an error at law, which will allow an appeal to a higher court. I had a friend client in the Sunshine Coast who sued a builder over faulty workmanship and breach of contract, and the judge in that case, it's really hard to explain, but I was there on behalf of this woman that I knew, and so right off the bat, the judge said, okay, here's this woman who can hire a lawyer and pay him and beating up on this poor workman. And so the trial went really badly. The judge was not impartial and unbiased, and actually got more like an inquisitorial trial where she got involved and told the other fellow what to say. Okay, and at the end of it, I had case law which pretty much said that this person should not win, and I provided it to the judge. Well, when she did her written decision, she ignored all the cases. Why? Because, what can you say? This case, the plaintiff should win, but I'm going to ignore it because I want the defendant to win. Well, that's patently wrong. So she just ignored it because it was small claims court, and it's very costly to then appeal to the BC Supreme Court. And so she figured that the plaintiff or the claimant would just give up. Well, the claimant appealed, and we got into the BC Supreme Court. And one of the points I made was that we had these cases, and that this was an error at law, which allowed me the appeal. And she made errors in the facts as well. So many, in fact, that when I was going through the appeal, the Supreme Court judge was sort of going, and finally he stopped me. He said, okay, Mr. Holden, what's your client want? And I said, I want the contract declared to be fundamentally breached, and the parties put back in the position they were in before the contract came into existence to the best of the court's ability. And he said, you get it. And the poor guy was there, and he didn't get a lawyer because he couldn't afford it, or just didn't think he needed it because he'd already won, and he had no idea what was going on. And it was based on precedent. Okay. So back to my example, Holden versus Graham. My lawyer brings in some cases, Graham's lawyer brings in some cases, and then the judge has to figure out what to do with those. I cannot ignore them. So what he or she'll do is look for one that is the guiding judgment and says what should happen. And then the judge will apply that decision. The rest, the judge will either consider, say that they were helpful but not determinative, or that they just don't apply for some reason and so they should be distinguished. Okay? Or if the judge looks at all the cases and says none of them are sufficiently on all fours, meaning exactly like the case at bar, so none of them give me the answer. So then the judge can't make new case law, but still has to consider or distinguish the other cases. Okay, so that's one thing. But what happens if my lawyer brings in some cases that help me, and Graham's lawyer brings in some cases that help him, but one of those is from Ontario? And let's say it's a Court of Appeal decision where mine are only Supreme Court, BC Supreme Court. Well, this is a higher court and a better decision, but it's from Ontario. So how do you apply an Ontario case in BC? Well, under common law, you can. Okay? So what you do is you say, all right, I'm going to consider or distinguish these other cases, and I am going to follow the case from Ontario. No, you cannot, apply. You cannot apply the law of another jurisdiction. Okay, that would just be patently wrong. But I can follow a decision of Ontario as long as it's a common law decision, okay? Now, if there's a statute involved in it, we have a statute law, and the case from Ontario is interpreting a statute, you cannot follow it because unless the statutes are exactly the same. Okay. So you can follow a law from another jurisdiction, or you can apply a law from a BC jurisdiction. Interestingly enough, in the material that I am going to post regarding this, in the Royal Bank versus Kiska case, which took place in Ontario, it was a court of appeal, 3 judges, 2 made a decision wrongfully. The third judge, who was very good, Mr. Justice Laskin, Mr. Justice Laskin, went on to be a Supreme Court of Canada judge because he was so good, one of the best judges we've ever had. He did a dissenting opinion. Okay, well, that dissenting opinion became the law in other jurisdictions rather than the decision of the court, like 2-1. Obviously, the wrong judges created a bad precedent. So, in a British Columbia case on the same issue, the judge said, I want to apply Laskin's dissent, which you can do, okay, because what you're doing is you're saying, that's good law, and I can apply it here, okay? So he didn't follow the decision in that case. He followed the dissent. Could the judge do that in BC? So if I brought in some BC Supreme Court judgments and Graham brought in a BC Court of Appeal decision where 2 judges made the wrong decision and the 1 judge made the right decision, can the judge in our case follow that case? No, he or she cannot, because the judge would be bound by precedent to follow the decision of the 2 judges, which was wrong, as opposed to following the dissent. So the judge would overrule that case. Okay? Say that it was wrongfully decided, and then the judge could adopt the dissenting opinion. Okay? Why wouldn't the judge just overrule the case from Ontario? Because a BC judge can't overrule law in another jurisdiction, okay? But can follow the dissenting opinion and say that the judgment of the court was wrong. Okay, so those are the things the judges can do. Now, distinguishing a case, I had a trademark case, and I had to go back to Ottawa to fight it, which was kind of fun. And I wanted to introduce some marketing, a survey that was done, okay? But it wasn't a statistical survey, it was a directional survey. And for the people in marketing, you'll know what I'm talking about. I wanted to introduce the survey evidence to support my client's position. The problem was that the survey was done by the defendant. So, and if I want to introduce survey evidence, I have to provide a statutory declaration or an affidavit of the company that did the survey as to its authenticity. Well, it was their survey, and their survey company, marketing company, is not going to give me an affidavit to help me fight them, right? So I looked at the case law that said you had to have this affidavit or a stat dec from the person doing the survey, and all those cases said if they wanted to introduce it, they had to provide it. Okay. Nor did any of the cases say that if I wanted to use their survey, I had to get an affidavit. And so I introduced the survey evidence, and the only way they could not or stop it from being introduced was provide an affidavit from their survey company saying it was irrelevant. Okay, and they wanted to rely on it too. So I got it in, but I had these cases that said I was supposed to provide it. And so I had to explain to the judge that those cases were irrelevant to the decision about whether I could introduce it, because they all said the maker, or the people that wanted to rely on it that made it, had to give an affidavit. And so what I had to do is I had to bring those 3 cases to the court's attention, even though they were adverse to what I was trying to do, and I had to convince the judge to distinguish them. Whew, that was hard to explain. I hope you followed me. But the whole point was there were 3 cases that were adverse to my client's position. And I put them in my book of precedents, and my client said, "Why are you putting those in there? Those are not good. They do not help us." And the reason I did that was, twofold. Number one is, if I did not put them in, and the judge said, "Mr. Holden, what about these 3 cases?" then I'd either have to lie and say, gosh, never heard of them. Or I would have to say, I know about them, but they were against my client's position, so I ignored them, which I cannot do because I'm an officer of the court. So I explained this to my client, and he was quite upset about it. But then when I went in and argued that these cases were not applicable, the judge actually distinguished them, made a decision that if they have affidavit evidence, survey evidence, I could introduce it, and then it was up to them to challenge its validity or not. So I created new law. Well, I shouldn't say I did. I gave the judge information that allowed him to distinguish those cases in our situation and create a new case covering my situation. So new law was created, okay, but I had to distinguish those cases. Okay, or get the judge to, rather. Okay, so those are the 5 things that can be done. And in the past, I've put a little question on the exam, because there's 5 of them, right? About what judges can do. So you might want to have a heads up about that. Okay, looking at international business transactions, they involve 4 things. One is the contract of purchase and sale between the vendor of goods and the purchaser of goods cross-border. Then there's the contract regarding the transportation of those goods from here to there. Then there's the contracts concerning the financing of the transaction. And then there's the contracts of insurance to protect the goods in transit. And we're going to look at each one of those individually. The first one is the contract of purchase and sale. It's just a contract, but because it's cross-border, it really should involve a number of clauses that some of which would be in a domestic contract, but some of which are particular to an international transaction. First one, all contracts should have a choice of law clause. Okay, so in Vancouver or in British Columbia, you don't need that, because if it's a BC business and a BC business, BC law applies. But what happens if it's a BC business and an Alberta business? Our laws are slightly different. So you should put in a choice of law clause. This contract shall be governed in all respects by the law of the province of British Columbia. Then you want to have a choice of forum clause, okay? And by that I mean you'd probably want to say, the BC International Commercial Arbitration Center shall be the forum, okay? Because you don't want it to go to court. But if you wanted to go to court, then you would say that the forum shall be the BC Supreme Court. Okay, then you might want to exclude conflicts of laws. Because the laws of BC and the laws of Alberta are slightly different, you want to say BC law shall apply to the exclusion of conflicts of law. That means if there is a conflicting Alberta law, the judge is not going to be able in some way say, well, I think that should impact it. Okay, it has to be just BC law. Then you definitely want to have a dispute settlement clause. This contract shall be any disputes with respect to the content of this contract or matters related thereto shall be reference to mediation and failing mediation arbitration pursuant to the International Commercial Arbitration Act. So if you have a contract between a BC business and a Mexican business, you actually have to put in a clause which says this contract has been fairly negotiated. Mexico demands that. It's the only jurisdiction, I think, that does. But they demand it because they've been beaten up so often by the Americans in negotiating contracts, because the Americans had the upper hand, that the federal government in Mexico said we have to put this clause in there so that if it's an overbearing, unconscionable contract, it can be declared null and void at the request of the Mexican business. Okay, so you put that in there, and it sort of forces parties to take a closer look at the way it's going to be applied. Now, there is this Convention on the International Sale of Goods, which was negotiated by the United Nations, and almost all countries are signatories to it, at least substantially. Most of the really commercially important countries are signatories to it. And what it does is tries to get rid of the conflicts of laws so that there's one set of rules that'll apply to the transaction. Well, Canada and the United States are signatories to that convention. And in Canada, because this is civil and property rights, each province has been a signatory to it. I don't know about Quebec. Let's not worry about it. But all the common law provinces have. So a contract between a BC business and a contract in Alberta, if there was a dispute, could technically wind up being covered by the convention. And there are differences, because when the countries are negotiating this convention, there were more civil law countries than common law countries. And so it follows more closely the civil law system than the common law system. So a BC business is dealing with an American business. One of the parties is going to put in a clause that says to the exclusion of the applicability of the Convention on the International Sale of Goods, because they want it governed by common law. Okay, so quite often I do talk about, in Part C of the exam, clauses that should be put into the contract in this respect. Okay, this is what's called boilerplate. Boilerplate clauses that lawyers put in contracts when the parties that are negotiating them would not have put in had they done the contract themselves, because they don't think about these things. Lawyers do. There are other clauses like that, and of course one of them is an entire agreement clause, so that there's no verbal representations that can be applied to it. Another one is execution in counterparts. Okay, you're here, there's a business in Missouri, you enter in a contract. Well, do you go down there and sign it, or do they come up here and sign it? Well, what happens is 4 copies made, 2 in the BC business, 2 in the Missouri business. The BC businessman signs each copy, sends one down to the Missouri business person. The Missouri business signs both copies and sends one up to the BC business. Once the BC business has his copy signed and the Missouri business is signed, that's a complete contract. Same with the Missouri business person. He's got a copy he signed and a copy that the BC business person signed. Bingo. It's called execution in counterparts. Okay, enough said on that. Been going for quite a while, so I think what I'm going to do is take a short break. That's about 48 minutes, so we'll have a short break. All right, back after my break. To finish off contracts of purchase and sale, we want to talk about one term, and that's counter trade. This is when instead of goods going one way and money going the other, goods will go one way and perhaps a little bit of money, but goods will go the other way. Let me explain. Pepsi-Cola was the first soft drink to get into the Soviet Union, and it was a very popular drink over there, and they were making lots of money. And so Pepsi was going this way, and they wanted money to go that way. The Soviet Union didn't have enough dollars, U.S. dollars, to pay, and Pepsi-Cola wasn't prepared to take rubles. Rubles. So what the Soviet Union did was they said, okay, well, guess what? You're going to have Pepsi come this way, and then going that way will be some money, but also some products of ours. So you had to take goods as payment. And what they forced them to take was vodka. And so in the United States, Pepsi-Cola was not only a distributor of soft drinks and juices, but they also had to get into the liquor distribution business in order to get the money out of the Soviet Union. That's an extreme case, but a lot of times, in order to help the balance of trade, governments of the importing company says you have to take some of our exports in return. All right, that finishes off the contracts of purchase and sale. Now we're going to look at the transportation of goods. And so this is the contract of carriage, because here I am in Vancouver and here you are in Australia. You buy my goods. We've got to get the goods from here to there. And then the question becomes, well, you're paying for the goods, but who's paying for the transportation? Who's paying for the insurance and things like that? So we have these transportation terms generally agreed upon, that describes the time and place for the buyers to take delivery and when risk is passing from the seller to the buyer. The terms were eventually over time becoming more and more consistent, but there was still some difficulties because the contract would say FOB, free on board, and the question then became, was it free on board point of shipment or free on board point of destination? And parties would get into disagreements over it. The International Chamber of Commerce stepped in and developed rules with respect to trade terms called Incoterms. Now, the International Chamber of Commerce is not a lawmaking body, but what they did is they drafted rules that business people could use so that each person would understand the nature of the contract of carriage. And eventually, when disputes arose, these became interpreted in courts, and the Incoterms began to take on a law-like appearance. So on the next couple of screens, we're going to look at the basic terms. Rules, a lot of goods are shipped by ship, carried by ships, and therefore those rules have been consistently used for a long time. FOB does not mean free on board. FOB is the acronym for free on board, but then the question becomes, what does free on board mean? Well, I'm in Vancouver and you're in Australia. Free on board means that I pay to get the goods from my place of business down to the dock. As the goods are lifted up and go over the rail of the ship that they're being sent on, risk transfers from me to the buyer. So the buyer has to get insurance, and then also the buyer pays from that point on. Okay, so I have to pay the trucking company to get it down to the dock, but then the buyer pays for the goods to be taken to Australia. FAS, free alongside. I pay to get my goods down to the dock. This is used quite often when the containers are going to be sitting on the dock for a long time, because okay, you're going to pay the insurance for the carriage contract, but that means I'm going to have to get substantial insurance because my goods are going to be sitting on the dock for a long time. So I can actually say, no, I'm delivering it to the dock. It'll be in a bonded warehouse, but as soon as I get it free alongside, which means close to the ship where it's loaded, risk passes to you and you pay. CIF means cost, insurance, and freight. And this is a situation that applies generally when the business in Australia is going to do a one-time transaction. Free on board, free alongside, they have to either use a freight forwarder, and that means a contractual obligation and payment, or they have to learn the whole system themselves as well as using a freight forwarder usually. Anyway, a one-shot deal, they say, look, you take care of everything, the vendor, and we'll pay for everything. So I'm the vendor, I arrange the contract of carriage, and I arrange the insurance, and I arrange the payment, and you pay it all. Okay? So the seller must arrange for the shipping of the goods and the insurance, but the risk passes to the buyer when the goods go over the rail of the ship, and from that point on, the buyer has to pay. Cost and freight is just an abbreviation of CIF. What that means is I will arrange for the shipment of the goods and getting it down to the dock and having it loaded, but you're going to get the insurance. I don't know why, but it just depends on the circumstances of the party. Okay, so anyway, that's goods carried by sea. Rules for any mode of transport. So this is sea, truck, rail, and plane. X works. This is the best for the seller. Here I am. Here's my operation. I go, all right, buddy, you come to my place of business. My goods are here. You pay to load them. You pay the insurance. Risk passes to you the second it goes over my loading dock at my place of business. It's the best for the seller because the buyer pays everything. In FOB, I have to pay to get the goods down to the dock. Okay, but hey, X works. You need me. I don't need you. You want my goods. You pay for everything. Free carrier is used most often with with trucks and with planes or rail, I guess, as well. And what that means is the seller delivers the goods cleared for export to the carrier. So if it was going by plane, I would take it out to the Vancouver International Airport, not to the passenger terminal, but to the freight terminal, which is on the south side of the airport. Once I get it there, I don't put it on the plane. I just have to get it to the place where the plane is. And once it's there and unloaded, bingo, it's your responsibility. Okay, same thing with trucks. CP Transport is a big trucking firm downtown. They or Cam Freightways or whatever. I'm sending it by truck. I get it down to their terminal in Vancouver, and then risk passes to you, and you pay from that point on. Carriage paid to. The seller must arrange for the shipping of the goods. Risk passes to the buyer when the goods pass onto the designated carrier. And the seller must deliver the documents to the buyer, and the buyer arranges insurance. Okay. CIP, carriage and insurance paid. Seller must arrange for the shipping of the goods and the insurance. Okay. And then a risk passes to the buyer when the goods are passed on to the designated carrier, whether it's a ship or a truck or a plane. Okay. And the seller must deliver the documents to the buyer. Okay, I've just got a notification on my computer that I have a low battery, so I'm going to have to plug that in, so we're going to have another short break. Now I'm plugged in, we got power, we're good to go. Cost insurance paid to, yeah, we've already covered that. So the last one is screen, which is 141. Deals with a situation where so far we've been delivering it to the carriers before they've been taken across the ocean or into the United States or whatever. Okay. Now this is a situation where the seller is responsible for getting it across the ocean to the other country. Okay. And so DPU means delivery at place, unloaded. So free alongside means I have to pay to get it down to the dock in Vancouver. Delivery at place means I have to get it onto the dock in Australia, Sydney, for example. So I will pay for the transportation to that point, and the goods will be at my risk, and I have to get insurance. Okay. Then delivery at place means I have to get it right to your business. So not only do I have to get it to the dock in Sydney, but I have to put it on a truck from there and get it out to a suburb in Sydney where you have your warehouse. And then delivery duty paid means it's the opposite of X works. X works is the best for the seller because he just says, okay, here I am, you come, you pay everything. Okay. DDP means, hey, you need me more than I need you, and so the seller, meaning you, the buyer, I need the buyer, and so I'm willing to pay everything to get my goods there. Okay. And so that's the opposite of X works. Seller is responsible for delivering the goods to the named place in the country, pay all costs in bringing the goods to the destination, including import duties and taxes, if any, and the seller is responsible for unloading. Okay, so I actually have to unload it, whereas the X works, the buyer is actually responsible for loading it. Okay, so after all that, you're sitting there thinking, oh, am I going to have to remember this for the exam? Well, the exam is open book. Okay. When we had in-class lectures on the exam, if I put on a problem with respect to Incoterms, I would give my students a sheet because there's no point in you memorizing this because you can always in life look it up. All right, so if that is on the exam, then obviously you'll be able to look at those and you don't have to memorize them. There's a diagram on 142 which really explains who pays for what and how all of those work. I'm not going to go through it now. You can have a look at it yourself. But then there's another diagram on 143 which talks about these new terms and shows you, for example, X works means everything happens at the place of the seller, and DDU and DDP, everything happens at the place of the buyer, and so forth. Okay, all right. Now, as far as the risk passing, it really is as it goes over the rail of the ship or the back of the truck. There was a famous case involving a CIF contract, cost, insurance, and freight, which means all the responsibility to pay and the risk is on the buyer as the goods go over the rail of the ship. It was an English case, a UK case, where they were selling aircraft tenders to India. Now, aircraft tenders, anybody know what that is? Probably not. An aircraft tender is a fire truck, but it's a fire truck that they use at the airport. And so instead of going out with a water hose, they generally go out and they spray foam to retard the plane, right? So these aircraft tenders were being sent to India, and they were being loaded by barge in the Thames River in London. And one of the aircraft tenders was going up, and the chain broke, and it fell down, and it landed on the rail of the ship. And the judge in the case said he could almost imagine the people on the dock and the people on the ship going to see whether it would fall in the water, at which point it had not yet been loaded, and therefore the UK company selling the tenders would be responsible, or whether it fell on the deck and the Indian company would be responsible. And of course, it broke and part fell in the water and part fell on the deck, and the next thing you know, they're in court. But there were other issues related to that that generated the court case. But that's how precisely it works. Okay, so documents with respect to the contract of carriage. Bill of lading is one of the most important documents, obviously. And there's quite a number of categories of bills of lading that you should know about. A bill of lading is a document issued by a carrier to a shipper that serves as a receipt that the goods have been shipped and evidence of the contract of carriage and a document of title. 3 things. Okay, that'll make a good exam question. A clean bill of lading means the goods have been properly loaded and stowed on the ship. A claused or foul bill of lading indicates that there's some discrepancy between the goods loaded and the goods listed in the bill. And a bill can be fouled en route. Okay. So, but generally it means that there has been some damage done to the goods as they've been loaded. And so it would become a claused bill. And then that claused bill is used for insurance purposes because it indicates at what point during the trip that that the goods were damaged. So a bill of lading can either be clean or claused, but a bill of lading can also be either a straight bill of lading or a ordered bill of lading. An example of a straight bill of lading would be Peak Performance Pontoons Inc. skis, because the distributor is in Australia and the manufacturer is in BC. Though the distributor that buys them wants to make sure that they get all the way there. Okay, and so it's called a straight bill of lading, issued to the named consignee, which would be G'day Mate River Rafting Ltd. Or whatever the Australian company is. An ordered bill of lading is one that's used in a different situation. And a really good example of that is Seville oranges, which come from Seville in Spain. And they are sold all over the world. But there was a buyer in England that wanted to buy Seville oranges. But they would be loaded on a ship in Barcelona. And by the time the ship got to London, the buyer was hoping that there were no oranges on board. Why? Because he wanted to sell them on the way. Well, if it was a straight bill of lading, the oranges would have to go all the way to London and then be sold and then taken back to wherever the buyer was. And so the ship would leave Barcelona and it would stop at Lisbon, and some of the oranges would be sold, and then it would stop at Le Havre, France, and some of the oranges would be sold, and then it would stop at Copenhagen, and some of the oranges would be sold. But you cannot do that with a straight bill of lading because the owner is in London, all right? So it would be an ordered bill of lading, and then the purchaser's agent would be on board and would have a letter of authority, and then the agent would sell en route. Okay, so you can have a ordered fouled bill of lading, which means some of the oranges have been damaged. Okay, so those are bills of lading. What's a bill of lading look like? It's a document. It used to be a multi-page document, and they would scribble on the top, and they would give that to the person as the seller as the goods are loaded, and then some damage would occur, and so the shipping company would mark down the damage, and then the ship would go to Hawaii, and the goods would be offloaded on that ship, from that ship onto another, and some more damage would occur, and they would mark it on the bill of lading. So the damage could either be during loading or en route. And that's just an example of the form, so you get some idea what we're talking about. You can take a look at it if you want. Okay, so that's carriage of goods by sea, and I just wanted to talk about the carriage of goods by air. Interestingly enough, we have the Carriage of Goods by Sea Convention passed by the United Nations. Passed by the League of Nations, which was the precursor to the United Nations, and it was subsequently adopted by the United Nations. And that was either something like 1933 or 1935. But before that, there was a Carriage of Goods by Air Convention. And strangely enough, they first flew an airplane in 1909, and by 1929, they had a convention, an international convention, talking about the carriage of goods by air. It was really easy to get through the United Nations because very few people really cared about it. How many had freight aircraft by that time? But anyway, it was signed in 1929. The Carriage of Goods by Sea Convention took a lot longer because people had been doing it a lot longer, and more countries had, some concerns about the development of it. Okay, the Carriage of Goods by Air Act, called the Warsaw Convention, was signed in 1929. The Hague Protocol updated it in 1955. The Montreal Additional Protocol number 2 in 1995, and then the convention, the Montreal Convention in 1999. It keeps getting updated along the way. I think the 1991 is the last one, but what it does is it says, slightly different than sending goods by ship, where they figure out the cost of things that are actually damaged and you have to get insurance. The airline companies were responsible for compensating you. So personal injury or death, it's called 16,600 special drawing rights. And a special drawing right a couple of years ago was 1.5 US dollars, okay? Which means, I get on board the plane and I'm sitting in first class because I've been bumped up. I couldn't afford to go myself. And I sit down beside somebody and go, "Hi, my name's Peter Roldan." "Oh, I'm Bill Gates." I go, "Oh, Bill Gates. Oh, really nice to meet you." Well, if that plane crashed, that's the only time I would ever be worth the same amount as Bill Gates. Okay. The airline would compensate him 16,600 special drawing rights, and or his estate, and they would compensate my estate 16,600 special drawing rights. Bill brings on his computer, which is worth $42,000, and I bring on my computer, which is an Apple computer, which would upset Bill Gates. Never mind. Anyway, the 332 special drawing rights would be paid to Bill Gates per kilogram for his notebook, and $332 special drawing rights would be paid to me. That's checked luggage. Our carry-on is 17 special drawing rights. So his computer, his laptop computer, he would get, what would that be, about 17 and a half, it'd be 8, like $25 for his computer, and I get $25 for mine. So they have set limits because they realize that if a plane went down, there could be a lot of people die, whereas very few people get shipped by ship, right? Except a cruise ship, maybe. I hadn't thought about that. Anyway, so they have these limits because they realize that air traffic is so important that they don't want airlines going out of business, which is sort of where we are now with COVID-19, but that's a different thing. Okay, so we have the bill of lading, which we've talked about, which is shipping by train and truck and ship, and then we have what's called an airway bill, which is a bill of lading, but with respect to goods being shipped on airplanes. An airway bill is slightly different. It is a receipt for goods, so I get a receipt when I drop them off at the freight terminal at Vancouver International Airport, and it's evidence of the contract of carriage, but it's not a document of title. I don't know why. Okay, it's just one of those things. If someone wants to look that up, you get some bonus points. Or bonus marks. Okay, so some other transportation terms that we should know. Everything gets shipped by containers now, almost everything. And containers are either 8 by 10 by 20 or 8 by 10 by 40. If you are shipping goods, the buyer can demand a full container load or less than a container load. Now, a full container load is more secure in the sense that if I'm shipping skis to Australia, the buyer can say full container load. Well, maybe my skis will not fill the whole container, but they say that way the container will not be opened en route. Okay, so it's more secure. The skis are more likely to get there. So I have to put the skis in, and then I have to do it in packing and bracing. And you have to be really careful of the materials that you use, because certain countries don't allow wood, certain countries don't allow plastic, certain countries don't allow metal for various reasons. Okay, so you have to check those. But I have to pack it so that there's no damage, it doesn't shift around. and it would be more expensive for me to send it. Less than a container load means that my skis go in, but other stuff goes in, other sellers' stuff. So the container is supposed to go to Australia, but the ship goes to Hawaii, where the container is opened and certain other goods are taken out and certain other goods are put in, and then it's reclosed, resealed, and then it goes to I was going to say Ho Chi Minh City, but that wouldn't be it. It would be Da Nang, a seaport, where it's opened up again, and some goods are unloaded and some goods are packed in it, and then it gets to Sydney, Australia. So there's more opportunity of damage in a less than a container load or theft. Okay, and so what you want to do is you want to if the goods are going to be loaded and offloaded, you don't want that, then you actually have to specify in the contract no transshipping, okay, which means the goods cannot be unloaded and loaded, and that will be a full container load, no transshipping, because then it goes right through and stays on one ship. Okay. All right. So now we're going to look at insurance, and let me just pop forward here. Okay. Insurance is number 4, and I've got payment following it. So I got some slides out of order here. So I'll switch those around. So I'm not going to say what slide numbers things are. Insurance is the 4th aspect. Somebody has to insure the goods. Ships go down all the time. I got some great pictures of ships on fire and ships going down and ships tipping over and ships caught in storms in my international trade law class. So you might want to consider taking that unless you've had too much of me already by that time. Marine insurance covers the loss of damage of ships, cargoes, terminals, and any transport or cargo by which property is transferred, acquired, held between points of origin and final destination. Okay, we don't really want marine insurance as Peak Performance Pontoons or the buyer. What we want is cargo insurance, which is a subcategory of marine insurance because that protects the cargo. 2 types of policies. There is a special cargo policy. Insurance is arranged for 1 trip. So somebody's going to buy some skis for their use. A company in Australia is going to buy 10 pairs because they want them. They would get special cargo insurance because they're getting 1 shipment. But a distributor who's going to be buying skis and selling them, buying skis and selling them, buying skis and selling them, will get an open cargo policy, which is almost like a revolving line of credit. Okay, the insurance is arranged to cover a number of trips. Okay, and then both special and open cargo policies, what does it cover? It covers loss of damage from sea, fire, jettison. What is jettison? You see those pictures of ships with, containers, piled so high? Well, when you get into waves and, rough seas, the ship begins to wallow. Now I had a sailboat. And on our sailboat, we had a gauge which showed how much you were tipping over because you'd have the wind and you'd be over like this and you'd be hanging out this side and you'd just be flying along, right? Well, you'd watch that gauge because if it ever got close to this point here, it was the tipping point when you turn turtle. So when ships are going like this and they think, we're gonna turn turtle, they go up to the top and they start pushing containers off into the ocean, and this is called jettison. This happens so often that people that sail from Vancouver to Mexico and Mexico to Vancouver are taking their lives in their own hands, as well as things like pirates, believe it or not. These containers go in the water, and as they fill with water, there's air trapped, and so they can float just below or just slightly above the sea surface. And you're going along a sailboat, you don't see that. Punctures your hull, and the next thing you know, you're lost at sea. And also at nighttime when you're sailing, generally you just hook up the rudder and you go to sleep, because you're heading to Mexico. Well, if you vary a little bit, it doesn't matter because you're heading south. But at night, you'd never see one of these containers. So it was always considered to be very dangerous because of jettison. Forcibly taking of the ship, Straits of Malacca, all sorts of, believe it or not, pirates that take the ship off of Somalia. Same thing. When my wife and I were traveling by cruise ship and we went through the Suez Canal and through the Red Sea and then out through the Gulf of Aden, at one point the ship's captain sent a notice around to everyone saying from 10 o'clock tonight until 6 o'clock in the morning, all outside lights will be shut off. Why? So that at night the Somalian pirates couldn't see the ship. We also stopped before we entered the Sea of Aden and took on supplies. And the supplies were actually weapons, okay, from a British gunship, just in case we got attacked by pirates. On a cruise ship, on a cruise. Hey, everybody's having a good time on a cruise. There has not been a cruise ship taken by Somalian pirates. There were attempts, though. Okay, forcibly taking of ships. Barattery. What the heck is barattery? Barattery is theft by crew. Okay, so my peak 100 pairs of peak performance pontoons do not arrive in Sydney. Only 97 pairs arrive. That's because the crew decided they would take 3. Explosion, fumigation, damage, and damage from loading, discharging, or transshipping of goods. Remember transshipping? No transshipping, which means you cannot have your goods taken off and put back on. All marine policies generally include a lost or not lost clause. Goods are covered by the policy even if destroyed prior to the policy being taken out. This is because in the old shipping days, English companies would buy cotton from India. And the cotton would be on the dock. Well, they're in England and they had arranged insurance. The insurance company would say, how do you know the cotton's still there? Well, you get on a ship and you sail for a month. Oh, yeah, it's there. And you sail back. Yeah, it's there. I want insurance. And they go, well, what happened in the month? And so it became impossible. So what they would do is they would guarantee the insurance at the time you took it out, even if the goods had been destroyed beforehand. Okay. Particular average is when the loss for something, a container, is borne by the owner only. And general average is when everybody agrees that all the cargo will be covered by everybody's policies, so that if my container gets jettisoned, I don't pay the full insurance cost of that. It's borne by everybody. All right, that is enough on insurance, and we're now getting into financing the transactions, which is a separate topic entirely, and it should have been ahead of the insurance, but I guess it doesn't really matter. So we'll get into that next. Okay, I have put in the financing as number 3. So now we finished the last part, the insurance, number 4, and we're going to kick back and do financing international business transactions. So the first screen we look at is 148, so that means the insurance screens. If I mention the numbers, they're wrong. Anyway, on 148, I have some material that the Bank of Nova Scotia provided to me when I had a guest speaker come out and talk to my international trade law class, and she allowed me to go ahead and continue to use it. What it shows is a risk barometer, and the whole thrust of this course is risk management, so I thought that was kind of perfect. And it lists open account, documentary collection, letters of credit, irrevocable letters of credit, irrevocably confirmed letters of credit, and cash in advance. So from the top to the bottom is the most risky to the least risky. Open account is when you sell on 30, 60, 90 days credit. So in other words, Peak Performance Pontoons would ship the skis to a company in Australia, let's call it G'day Mate, and the date from the delivery, they have 90 days in which to receive the goods, sell the goods, and then pay. Well, the difficulty with that is a lot can happen in 90 days. Ships can sink, insurance policies can go south, contracts can expire, all sorts of things. So the good A-mate could go insolvent, and so consequently, this is very risky. Okay, locally, if you sell 30, 60, 90 days, not as risky, but international trade, very risky. Documentary collections is almost as risky. What you do is you provide all the shipping documents to confirm that the goods have been shipped and insurance is in place and all that sort of stuff. And then they send you a bill of exchange, which is basically a check. Well, checks can boing, boing, boing bounce. And so consequently, that method is also very risky. Letter of credit. We are going to get into letters of credit in a big way because doing business internationally, one of the smartest things you can do is use letters of credit. What happens is the buyer goes to his bank and arranges a letter of credit to be paid to the seller. Once that letter of credit is arranged, the buyer is basically out of the picture as far as payment goes, as long as the seller can provide the documentation to show that the goods are in good condition and they were shipped and everything. The bank is required to pay. And there's nothing that the seller can do. The seller cannot go back and say, "Oh, look, I don't want this to go through," except if it's just a straight letter of credit. Okay, so open account, dangerous. Documentary credit, bills of exchange, dangerous. Letter of credit, better, but still dangerous because the buyer, for some reason, could have a change of heart and say, "No, I don't want to buy the goods. Cancel the letter of credit." However, if you specified that payment would be by irrevocable letter of credit, once the letter of credit is set up with the buyer's bank, the bank is bound at law to pay out regardless of anything else, okay? Pardon me. So you want it an irrevocable letter of credit. But let's say I am selling goods to the buyer in Australia, and he gives me the name of his bank, and it's the really solid Bank of West Wales. Well, any bank that has to say it's really solid probably isn't really solid. So consequently, I want to accept the letter of credit, but I'm a little from Missouri, which means I don't trust them. So you can ask that that letter of credit be confirmed. So what that means is the really solid Bank of West Wales will provide the letter of credit, but a bank like Barclays Bank or Dow Chemical or Bank of Japan say that yes, they know that bank, and so they are willing to guarantee payment. If that bank should go insolvent for any reason, the confirming bank will pay. Okay, so that's a really safe method of payment. Now, obviously, the safest method of payment is, say, you give me the money, I'll ship you the goods. From Good A-Mate's perspective, that's really risky. Okay, I send you the money and hey, where are the goods? So obviously, the open account is very dangerous for the seller, and cash in advance is very dangerous for the buyer. The letter of credit, irrevocable, confirmed, is the most confident way of being paid in between those two. So risk equals the buyer, okay, plus the country, plus the bank. And I say that because the buyer might go insolvent. You're dealing with a country like Russia, lots of corruption, and you're dealing with a bank that might not be solid as you think. So that's the risk barometer. The other thing that the Bank of Nova Scotia provided me is on the next two screens. And again, it's risks in international trade, and it breaks down commercial risks and political risks. Oh, pardon me, my allergies are driving me nuts here. It's a terrible year. Usually my allergies are over by the end of May, beginning of June, but it's been such a wet sort of growing season. So my apologies. Okay, commercial risks, insolvency. That's when the buyer goes insolvent. So the buyer is going to pay us, but they go out of business. Okay. Irrevocable letter of credit means the money's already with the bank, so you'd be protected against that. Repudiation. The buyer refuses to accept the goods. I had a client who sold Oriental furniture in a retail operation in Vancouver, and a business out of Puerto Rico bought a huge amount of goods, furniture for his business operation. And my buyer shipped it all the way down to Puerto Rico. This person paid by credit card, and you think, oh, credit card, that's pretty safe, right? The goods arrived. He refused to accept the goods, so he was repudiating the contract. The problem with that, of course, is the goods are down there. They've been released from bond. Now my client's going to have to pay to have it shipped all the way back, and the furniture disappeared. Okay, theft. Okay. Fortunately, we went to court and sued the bank. And in court, they had, what happened was he called up and he canceled his MasterCard payment, which you can do for non-delivery. It's one of the reasons that you can cancel. And we sued the bank and we said, no, it's your bank's MasterCard, and we're suing you because the goods were delivered. Now, there's a difference between refusing to accept the goods and the goods being delivered. So if I was shipping something to Puerto Rico FOB, I'd put it on a ship, or if I said an FCA, I'd put it on a flight. Delivery takes place there. I've delivered the goods at law. When they arrive, if you refuse to accept them, you're not saying, hey, delivery has not taken place. Get where I'm going with this? So they refused to accept the goods, and they canceled the credit card. But then we went back and said, you cannot cancel that credit card payment because the goods were delivered. The credit card says you can cancel if the goods were not delivered. He refused to accept it, but they were delivered, and so we actually got the money. Okay, so repudiation. The buyer refuses to accept the goods. If it was payment on 30, 60, 90 days, and or if it was delivery duty paid, delivery hasn't taken place yet, and you'd be out of luck. Okay, foreign currency exposure. I'm sorry, in there is default. The buyer just defaults on payment on the due date. Okay. The foreign currency exposure is transaction risk in receivables. So I'll give you a personal example of this. My wife and I used to go down and camp all the time at a place called Seal Rock on the Hood Canal in Washington State. We loved it so much, we thought, well, let's buy a cottage. So we bought a waterfront cottage down there, and we bought it at the beginning of August. We closed the deal, and we wanted possession by the beginning of September so that we could use it in the fall. Well, we did the deal on August the 1st, according to what the exchange rate was. And then by September the 1st, when the transaction actually took place and the money was paid, in that 1 month, the dollar had fallen in relation to the US dollar, and we're paying in US dollars, and it cost us $7,000 more to buy that cottage than we thought. Okay, so foreign currency risk exposure can be considerable. All right, just to complete that, we owned it for years and years and years and years, and then when we went to sell it, the buyer was a Canadian, and the buyer was American, and they paid in American dollars, and the Canadian dollar was dropping, and so we got to convert our American dollars into Canadian dollars and got a lot more. So it worked out okay in the end, but it was a bit of a hit when we were buying it. Okay, documentary problems. There's problems with the documents, so payment doesn't take place the way it should. Those are the commercial risks. Political risks, war, civil disturbance can prevent shipment of goods or the transfer of funds. Foreign exchange conversion. A country may not have sufficient U.S. dollars to pay, and so the country just says, okay, that's it. We are halting foreign exchange transactions for a time period, or the transfer of funds might be blocked, and like they did in Russia with Pepsi-Cola, and they said, no, we're not giving you the money. What we'll do is we'll give you counter trade. And then the permit problems is one that Canada has experienced. A few years ago, Canada made a big issue about toys being made in China and painted with lead paint, which isn't good for kids, right? It was a big scandal because in their factories they had people that were doing these minute little paintings, and to get a good point on the brush they would dip it in the paint and they'd go, and they were ingesting lead and dying. We didn't want our kids to suck on the toys and die or be affected by the lead paint, so we said we're not importing any more toys that are from China until such time as they change their policy. China turned around and said, oh, well, you know what? We're not importing any pork from Canada because of mad pork disease. Well, there is mad cow disease, but there is no such thing as mad pork disease, but they just said there was and stopped imports. And the pork producers in Canada, who had nothing to do with any of the problem, found themselves caught in politics. And so Canada actually had to negotiate with China, and we backed down, and we said, okay, you take the lead out of your production process, over 5 years, and then we're satisfied, right? Something like that. But anyway, permit problems can be a real issue. Okay, so those are the commercial risks and political risks associated with that. One of the best ways to get around this is, of course, by letters of credit. Before we talk about that, I just want to mention tender of performance. You always have to be ready, willing, and able to tender performance. So, for example, if you arranged a letter of credit because the buyer, you're buying in this situation, you're buying and you arranged a letter of credit and it costs you money, and it looks like the supplier isn't going to be able to supply you, so you cancel a letter of credit. Well, unless you've repudiated that contract, they say, oh, wait, okay, good, the goods are shipped. Where's your letter of credit payment? And you're not in a position to tender performance, you're in breach of the contract. Okay. A simple example of this is, let's say someone says, I'll sell you my car for $3,000. And you say, great, I'll meet you at 5 o'clock in the parking lot at Capilano University. You bring the transfer papers, and I'll bring the payment. So you turn up with a certified check for $3,000. They turn up with the car and the transfer payments. They don't want to sell it to you anymore, so they want to get out of the deal. How can they? You say, here's the payment, and you go, no, you did not tender performance. They go, yes, it is. Here's my certified check for $3,000. And you say, no, I said I would sell it to you for $3,000 cash. But this is as good as cash. No, it isn't, because the contract specified payment in cash. All right? Another example of tender of performance is some tenants in commercial complexes would take over the premises, and when the first rent payment was due, they're sitting there with the rent payment waiting for the landlord to come and get it. Well, the landlord does not have to come and get it. You have to search out your landlord and pay. You have to pay at the place designated in the lease agreement. And if you do not do that, you are in default of payment, and they can actually slap a lock on the door and close you out of your business. Okay, so tender of performance is really important. You have to figure out how the money is to be tendered. Okay, a way to get around that, and a way to get around all these other problems, of course, is to arrange payment by way of letters of credit, which is an instrument issued by a bank at the request of the buyer, obligating the bank to pay the seller within a certain period of time upon presentation of the documents specified in the credit, okay, by the buyer. There's types of letters of credit, and I think we'll come back to those at the end. I'd like to finish talking about letters of credit first of all. Okay, so here's a little diagram on slide 152, which shows the beneficiary is the person, the seller, who's selling the goods to the account party, who is the buyer. The account party arranges a letter of credit with their bank, called the issuing bank. Pretty easy to remember because they're issuing the letters of credit. The issuing bank sends the letters of credit to the advising bank. Who's the advising bank? It's the seller's, the beneficiary's bank. Okay, the advising bank receives the letter of credit. What do? They advise the seller that they've got it. So it's really easy to remember those. Okay. And once you get that, then you know the documents that have to be provided in order to complete the transaction. But if it's the really solid bank of West Wales, you say, oh, no, that's not good enough. So the issuing bank then goes to the Barclays Bank or the Bank of Japan or the Australian National Bank and says, will you confirm our letter of credit? And then they're guaranteeing payment, okay? Now, the shipping of the documents is the really important part as far as the seller is concerned. And that's because there's generally there's generally five documents. There's a certificate of origin, a certificate of inspection, commercial invoice, bill of lading, and a marine insurance policy. If it's perishable food, or if it's something that requires an export license, then there's a sixth document, okay? So those are basically the documents that have to be provided by the seller to the buyer's bank in order to have the letter of credit released, okay? You're not giving it to the buyer. I mean, you do give them copies, but that's not important. The documents have to go to the bank. The bank inspects them completely separately from the client. And here's the kicker. On the next slide, I talk about de minimis non curat lex. Contracts have conditions and warranties. Okay, not warranties and we warrant our goods for 30, 60, 90 days. No, it's slightly different. A condition is a term of the contract, which is if it's breached, the buyer can cancel the contract. Okay, it's a term that is incredibly important. Delivery by a certain date because I have to provide it to so-and-so or I'm in breach of that contract. It has to be of a certain quality, absolutely, because nothing else will be acceptable. So that would be a condition. A warranty would be something like you are supposed to provide 5,000 bags of a product. And for some reason in the shipment, only 4,997 bags were put in. Well, hey, I didn't get what I was, contracted for. The contract is canceled. No, you cannot do that, okay? Because the courts say we're not concerned with trifles. 3 missing bags is not enough to allow you to cancel a contractual obligation. What you do is you have to accept the 4,997 and have an adjustment in price. Or in the next shipment, get 5,003. Okay, settle that with damages, okay? You are not going to cancel the contract. Courts do not like canceling contracts. So that's the concept of de minimis non curat lex. Some minor discrepancy will not be allowed to affect the contract. The contract must be performed with some adjustments. Okay. Not so with letters of credit. There's this thing called the rule of strict compliance. The documents that the seller sends have to match the documents that the buyer's bank has perfectly, absolutely perfectly. I've noted on the slide that there's a type of bean called a SORAN. A typo in the letter of credit said SOFAN. Everybody knew that SORAN and SOFAN was the same thing. It was just a typo. But the bank said, hey, we're not paying out. Okay. Now, it wasn't that the buyer or seller did not get their money, but it delayed payment for a long time because they had to go back and they had to change all the documents and get it all corrected and then send it through again. Another one was when there was a wrong postal code, like a postal code. A postal code of the buyer, like who cares, right? But well, the bank did because their rule is that they have to match perfectly. Then they are obligated to pay out. So much so that if the seller, instead of putting skis in the container, puts straw and bricks and perpetrates a fraud, The bank still has to pay out if the documents match. The buyer can't say to the bank, hey, they're perpetrating a fraud on us, cancel the letter of credit. These things are so strict. The bank has to pay out, then the buyer has to sue, okay, for fraud. Okay, so de minimis non curat lex means minor discrepancies are acceptable, not so in letters of credit. Letters of credit have to match perfectly. Now we're just going to go back and look at the types of letters of credit. There are revocable letters of credit. Why you'd bother, I don't know. I did have a client that was going to sell his product to Japan, received a letter of credit from the Bank of Japan, and sent it to me for review and said, look, isn't this great? And I went through and I said, no, it isn't, because this is revocable. And he went back and they very quickly changed it to irrevocable, but he could have been caught. So, and then there are irrevocable letters of credit. Then there are irrevocable confirmed letters of credit. So the bank says, yes, this is irrevocable, and yes, we have a bank that's confirming payment if we don't. Then there are transferable letters of credit. So I received the letter of credit. It's worth a certain amount of money, or I'm going to receive it. So what I can do is I can say, oh, I owe so-and-so the same amount of money, so I'll just, transfer, I'll negotiate my letter of credit. Instead of making it payable to me, I'll just, we'll put your name in there and you get the money. That's negotiable. Back to back is if Peak Performance Pontoons is selling to Gadamate, a distributor, and the distributor is selling to another distributor in another country, then they have to get a letter of credit to pay me or Peak Performance Pontoons, but they can get a back-to-back letter of credit, which they can then use to complete the other transaction. Transferable, pretty much the same thing as a negotiable one, except if the Really Solid Bank of West Wales is giving Peak Performance Pontoons a letter of credit, they could negotiate it to somebody else. If Gadamate gets a letter of credit and Peak Performance Pontoons says we don't have enough money or skis to meet your commitment, so maybe you better buy them off this company, then that letter of credit can be transferable from Peak Performance Pontoons and make it payable to the other company. Then there's a revolving letter of credit. Gadamate is going to get a letter credit to buy our skis. And then the next shipment, they get another letter credit to buy our skis. And then the next shipment, they get another letter of credit. Well, every time they do that, they pay a fee. So they just get a revolving letter of credit, which will buy this shipment, and it'll be there to buy that shipment, and it'll be there to buy that shipment. Okay. A clean letter of credit, I had to look it up. We're going to do the payment by way of documentary credits, or document. Back to slide 148, documentary collection. Okay, we send the documents, and you send us a bill of exchange. You always deal with bills of exchange. So what you do is you say, I do not want, I'm willing to accept a bill of exchange from you, but I'm not going to have the bill of exchange held up by the letter of, by the rule of strict compliance. And so what you do is you say, where is it there? What you do is you say, this will be a clean letter of credit. So the letter of credit is there to support the bill of exchange, not to support the transaction. Okay, so it has nothing to do with the documents. And the letter of credit is clean, which means we're just supporting the bill. It's not, none of the documents can follow it up. A standby letter of credit. Some landlords now, you have to give a deposit. Okay, you pay the first month's rent and you give a deposit, basically the last month's rent. Well, I had a client who was leasing a hangar at the Abbotsford Airport, and the Abbotsford Airport said, we want you to pay a deposit they said, but we don't want to put it into the bank account and then hold it and calculate the interest and everything. So why don't you just get a standby letter of credit, which says if you default, then we can apply this to the last month's rent. Okay. All right. So back to the documents to be provided, the standard documents. A certificate of origin is a document that must go with all overseas shipments, and it just says where these goods are from. So are they Canadian goods or are they American goods that we've imported and we're now selling? Oh, that's my allergies. Pardon me. I had to send $600 worth of law textbooks to the Open University in Vietnam because they needed it for their library. So this was a donation, a charitable donation that Kaplan University was doing. And I needed a certificate of origin, and I found out that I had to take this document down to the Board of Trade and pay a small fee, and they go, okay. Now, they don't know that the boxes have law textbooks in them. It could have bricks in there, it could have drugs in there. Although why you'd be taking drugs to Vietnam, I don't know. But it could have guns in there. They don't care. It's me. They're certifying that I'm saying that those boxes are full of books. Okay, so I had to get a certificate of origin. That's one thing. An export license, there are some products that require that. It used to be that computer technology was so incredibly proprietary that if you bought a computer, you could not ship it to overseas. Okay, now all our computers are made over there, but you could not export computer technology without an export certificate. Okay, if I'm selling pork to China, I need a health certificate saying that it's all okay. And then this another one is if a certificate of inspection. If G'day Mate in Australia is concerned that the goods are actually in the container because they're worried about fraud, or that the goods are of a certain quality, or that the right number are in there, they can ask for a certificate of inspection, which means that somebody checks, an agent, usually a freight forwarder, checks the goods that go into the container. It's locked and sealed. And then they provide a certificate to G'day Mate saying, yes, at the point of shipment, everything was copacetic. Who pays for that? Well, if G'day Mate asks for it, Peak Performance Pontoons would have to get it done, but generally they would make G'day Mate pay for it. Okay. Then there's a commercial invoice, that's just the bill of sale. And then there's the bill of lading, which we've already talked about. And then there'll be a marine insurance policy, generally a cargo policy. Okay. And all those documents get packaged up. A copy gets sent to the buyer, and the originals get sent to the the issuing bank. Okay. And then the issuing bank checks those against the ones they've got on their file. If everything's okay, payment is made out. All right. We've done insurance. And here we are, slide 157, and it says the end. That's all the lecture material for the course. There will be one more video that you'll have to watch. Well, you don't have to, but you should, and that will be the one where I go over last year's final exam in preparation for this year's final exam. So I'll go over it. You should do it ahead of time because it will be posted on eLearn for you to do that. If you do it ahead of time and then you check it against my answers and listen to my video, you will do better on the final exam. Okay, if you just decide to go, I'm too busy, I don't have to do it, it's open book, what the heck, then you can watch my video, get the answers, but you will not do as well in the final. Simple as that. Okay, that ends the lecture component of the course. Thank you very much.